So we're going to be looking at, first of all, and it's going to be very much a sort of whistle-stop tour here, of to help you consider all the options for your client. How will the court actually look at those actual words in the documents? Will they actually interpret those words the way your client wants them interpreted? So in other words, will interpretation work and you don't need to go any further? Can you actually say that even though you don't think the words might mean that, or that they're ambiguous, has the court actually got an approach that would help your client? And indeed, has the court introduced a stricter approach following Arnold and Britton, or a more generous approach to interpreting the drafting following Wood and Capita? If that doesn't work, and when looking at the interpretation, of course, the court will just look at the words on the page. They might go a little bit further, but they cannot look at the pre-contractual documentation. Alternatively, could you say, well, actually, it's quite clear that this should have been in the document. I mean, it only really makes sense if this is in the document. I know it's not there, but it only makes sense. So can you ask the court to imply a term into the document? So where the clause that you hope that would make the document make sense is missing, will the courts imply that clause in? And what happens where there's an error in the drafting? Where there's a mistake, will the court correct that mistake, or will it actually rectify the document? In other words, undo the mistake that's actually happened. And certainly when it comes to rectification, the courts are going to look behind the document at the pre-contractual correspondence and documentation between the parties. And so it can be very useful in interpreting a document to also look at the pre-contractual correspondence, but bear in mind that if you ask the courts to interpret, they won't look at that. So if you ask the courts to interpret, you might want them to ask them to interpret, and in the alternative, rectify. And we'll see why, but it's all to do with that pre-contractual documentation. So when we draft, we do so really to reflect a deal that our client has negotiated and to record that deal that the client's negotiated, and to ensure that the deal that's negotiated, whether it's an overage deal, whether it's purchase of land, sale of property, granting of rights, granting of a lease, etc., we want to ensure that what the client thinks it's entered into actually works out in the way that the client intends. And so what we want to look at is what happens where it goes wrong and is disputed, or the meaning is disputed. And what happens if, as I say, some other idiot's drafted and you now have to advise on the effect of that drafting. So we're going to look first at interpretation, and then we're going to look towards the end at implied terms and what happens with mistakes, and in particular, where that's a mistake that a clause was left out in a document, or a mistake that a clause was entered into a document where the parties didn't intend that to be the case. So somebody just took their eye off the ball at the last moment.